The hearing today and tomorrow is aimed at talking about and analysing existing legislation and the way in which this legislation is applied in the various member states of the EU as far as protection and the right to defence is concerned.
The discussion about the European criminal law, I mean a criminal legislation of the European Union itself, may be considered as largely misleading. National legal traditions and comparison of them are still fundamental in enhancing a high level of protection of human rights.
In the past, the standpoint which considered criminal law and justice to be primarily a means to protect society against criminality as a negative phenomenon par excellence undoubtedly dominated. In modern democratic societies, the increasingly prevalent standpoint is that which emphasizes that in criminal proceedings, a participant who is weaker in comparison to the repressive state apparatus must foremost be protected.
Everyone that the criminal proceedings is being held against has the right of the defense. That means both material and formal right to defense. Before I start to speak about more detailed rights of vulnerable persons, I have to say that this term vulnerable persons is not recognized, of course, by the Criminal Procedure Code, but when taking into account some special provisions regarding certain categories of persons, we can say that we can recognize some categories of persons who we can involve to the term of vulnerable persons.
For administrative proceedings, not judicial proceedings, aliens can be granted free legal aid. So, first of all, Article 17.3 of the Spanish Constitution clearly states that any person detained needs to be informed immediately and in an understandable way of their rights and the reasons for their detention.
The witness may consult a lawyer if he or she believes that his or her testimony will be self-incriminating or will incriminate their close relatives or people they have close relations with, which is our term for people's partners. The right of defense, as it is developed in the Criminal Procedure Code, is, as you can imagine, subject to a lot of criticism by reports of human rights organizations, by reports of ABAC, where I worked, by reports of organizations like the Open Society Institute, who in Bulgaria conducted civil surveillance over police stations. Let us mention some of the criticisms very early on in my presentation. One of the criticisms in those reports concerns access to clients.
The Rome Statute was adopted in 1998, establishing the International Criminal Court. But it took another 4 years until 2002, until the elements of crimes and the rules of procedure and evidence were adopted.
Very briefly, the legal framework comprises of, first of all, the Swedish Constitution from 1974, the second chapter, section 23, referring to the European Convention on Human Rights, which means that, of course, a suspect must understand the charges. And then we have also the Swedish Code of Administration, section 9, which states that any public authority that will have contacts with foreigners, not non-Swedish speaking persons, are obliged to engage interpreters.
We could speak about the legal system and legal regulations on the theoretical level for a long time. I could present that information for hours probably, but let me say that in few words. In Polish legal system, the right to defense is, of course, based on the constitutional ground. It is just yesterday that there was the 10th anniversary of the Polish Constitution, And yesterday in the Constitutional Court we had this small celebration of that fact, which I wanted to mention now. About 5 years ago, a group of NGOs in Eastern Europe got together to monitor to degree to which governments were complying to the requirements of the European Convention and the national constitution with respect to access to justice, emphasizing legal aid rights. And the reason for the timing in 2001-2002 was the following, that those countries were going to join the EU in 2 years. Another important reason for inconsistent implementation of the right to legal aid is the lack of unambiguous standards of effective indigent defense on national and international levels, and the absence of sufficient incentives or leverages in this regard. The right to free legal aid for indigent criminal defendants should be real and effective, as is proclaimed in one of the judgments of the European Court.
The norm states that in case there is a need to interview a witness who may incriminate himself, it's the prosecutor who can take this decision, but only in the presence of agreement of that particular person. First of all, this norm is applied to persons who have certain immunities, like MPs, judges, etc. In other words, there is no need any longer to go to the Parliament to ask for a waiver of immunity in cases when the person himself comes to the prosecutor and asks to be interviewed. So the status is now a mixed one between a witness and a suspect.
Our judicial system was developed since the legislators had found that a complementary level should be come into the system in order to take off the burden of the very jurisdiction from the Supreme Court of the Republic of Hungary, and since that, this highest forum shall deal exclusively with the principal arrangements of the judicial principles and practice. Nevertheless, the requirement of a more effective, multi-level legal remedy system has also been realized by that.
In Italy, as we know, the right to defense is recognized at constitutional level in our constitution in Article 24. And this provision introduces a very reassuring wording because it describes defense as an inviolable right at any level of the legal proceedings without any restrictions.
In the elaboration of the new code, we start from the premise that an equitable criminal proceeding that takes place within a reasonable term cannot be ensured without its settlement on the pillars of new principles, which along the classic ones oblige the legal bodies to enforce an independent and impartial justice.
Within the context of the AGIS program, and considering that the European Union goal is to reinforce the quality of justice in the Union, we thought to carry out a study on the right of defense. Needless to say that the right of defense is a very wide subject.